And just say by way of introduction, I certainly have myself personally have followed Brian Stevenson's career and the work that he has done to address people who've been unjustly convicted and incarcerated. And I am a fan of TV shows that purport to describe cases like this. And so I have a great affinity for righting wrongs and correcting errors. And I am looking forward to hearing the real life stories and work of the Innocence Project. So very grateful to Dave McBride for organizing this and engaging Judy and Megan. So at this point, I will turn it over to Dave for introductions. If those of you who are watching would mute yourselves, that would go well for the recording process so that you don't pop up in the middle of the recording unexpectedly. So Dave, take it away.
Well, it's my pleasure to introduce Judith Ritter, who's the president of the Delaware Innocence Project, and Megan Davies, who's the executive director of the project. And let me tell you a little bit about both of them before I turn this program over to them. Judith is a distinguished professor of law at the Widener Law School in Delaware and serves as the director of the law school's Criminal Defense Clinic and as the director of the Tasoff Advocacy, Technology, and Public Service Institute. I hope I pronounced that close to right, but she received her BA summa cum laude from the State University of New York at Buffalo and a JD cum laude from Georgetown University Law School. That's the law school, by the way, Judith, that I couldn't get into. She began her legal career as a public defender in New York, where she tried felony and misdemeanor cases. She became an associate professor at Widener in 1994 and a distinguished full professor in 2004. She founded Widener's Criminal Defense Clinic, which has been providing representation to indigent defendants since 1995. She teaches criminal law, criminal procedure, evidence, and federal habeas corpus, and she speaks and writes about a number of criminal procedure issues. Megan Davies is the executive director of the Innocence Project, where she focuses on exonerating the innocent who have been convicted in Delaware and reforming the system that wrongfully convicted them. She worked full-time through law school and started her own law firm after law school, focusing solely on criminal defense. She's handled hundreds of criminal cases ranging from drug offenses to homicide and complex racketeering charges. She has tried over a dozen jury trials in state and federal court and has argued before the highest courts in Delaware and New Jersey. She graduated with a BA from Temple and received her law degree from Rutgers, where she's an adjunct law professor and serves as the lead coach for Rutgers National, I got Russia on the brain, Rutgers National Trial Team. With all that, she still maintains an active federal practice. These two women, I would say, are the heart, soul, lungs, and brains of the Delaware Innocence Project. Without them, literally, there would be no Innocence Project in Delaware. And I am very proud to turn this program over to them and thank them both for presenting tonight for us. Judith, Megan, the floor is yours.
Well, thank you so much. I'm going to speak first, and then I will turn it over to Megan. Thank you, Dave, for that lovely introduction, and thank you for inviting us, and thank you for being interested enough in us that you approached me a couple of years back to say that you would love to help as we were getting this project off the ground, and it's been a huge pleasure. We're very grateful for all your support. And thanks, Sue, for making this happen, and to the congregation for asking us. I have to laugh a little, Sue, when you said that you love watching the TV shows about this kind of thing. And people are always saying to me, you've got to see this series, you've got to see this, you'd love it. And I don't like to watch that stuff because it's like work, you know, it just makes me anxious. I need to escape. But in any event, I'm going to just talk a little bit about wrongful convictions in general and about how the project, the Innocence Project in Delaware, came to life. And then Megan will give you more details about that. I'm not going to throw statistics out at you. You can find them online about wrongful convictions, but I'll just one number. As of yesterday, there have been 3,000 exonerations in the United States since 1989. And this is really all over the country. There are some counties in the US where there have more wrongful convictions and thus exonerations than others, and they tend to be large urban counties in the North and the South, and many counties in Louisiana. But it's not limited to that. It's everywhere. There have been exonerations after an innocent person has been convicted in every state, including Delaware. And about half of the people that have been exonerated after innocence has been demonstrated, about half of those people are African American. And if you are an African American person, you have a 50% chance, greater chance than anyone else, of being wrongfully convicted. And these are numbers from the National Exoneration Registry, and I won't do any more with numbers, but there's really mind-boggling statistics actually on their website. So if you're interested in more, that's where you should go. And I also want to just emphasize, because sometimes I am very focused on the death penalty in a lot of the work I do. These are exonerations of people who are on death row and have been on death row for a long time. But it's also, of course, people serving life sentences or just long sentences in prison that are also exonerated. They tend to, I mean, I wouldn't suggest that people convicted of less serious crimes are not also sometimes innocent. They are. Those things don't come to light anywhere near as much because the resources are just not put into seeking, to remedy wrongful convictions when someone is not served time or served a very little bit amount of time. Let me just tell you a little story about how the idea of having an Innocence Project in Delaware came about. In about 2016, a man was released from Delaware who had been on death row for about 20 years. He was released after some lawyers, originally from the Federal Defender Office in Philadelphia, so Pennsylvania lawyers, represented him over a lot of years trying to establish his innocence and have him taken off of death row and out of prison. And a lawyer in Delaware, civil litigator, agreed to be the local counsel because these lawyers were not Delaware lawyers. He developed a strong passion for doing this work. And he approached me because he knew that this was, something I was interested in as a professor at the Delaware Law School, and said, I think we need an Innocence Project in Delaware. And at the time, there were Innocence Projects in almost 40 states and not Delaware. And so we put our heads together and pulled in someone else from the law school. And we started to see if we could talk to others about supporting the idea for having a project in Delaware. By the way, the lawyer, the civil litigator, and the person who was freed after 20 years on death row are currently on our board. In any event, we tried to get going, and it wasn't until we got 2 large federal grants from the Department of Justice for freeing innocent people that we were able to actually do something real as opposed to just trying to plan and talk about it. We hired an executive director, Megan Davies, who is brilliant and tireless, and we just don't know how we got lucky enough to find her. And we've hired a full-time investigator who's phenomenal. And we could probably use 3 lawyers and 3 investigators already because we've been very busy, and she'll tell you more about that. But we've opened up our doors. It's almost 2 years that Megan's been with us now, and she has received numerous requests for representation. And it's quite a large production to go through those requests. As you might guess, many people request representation, and yet the proof of innocence may not be there. And we will only take cases where we believe that we can make a case to prove their innocence. Once the first level of appeals is finished, it's called the direct appeals, the burden is completely on the convicted person to prove their innocence, as opposed to at the trial where the burden is to prove guilt. The burden is on us to show that our clients are innocent. So let me just speak a little bit about how that happens, right? How does it happen that someone who's innocent is convicted? And really, how come it happens as often as it has happened, as we've seen? And there are a number of reasons for it. And I'm just going to mention a few and just say a little bit about them. And then, of course, if you have questions, I'd be happy to talk more about it. One of the largest things that have been found to have caused a wrongful conviction, sadly, is misconduct on the part of the prosecutor or the police officer or both, or police officers or both. And the misconduct takes on a number of different different tactics, really. Probably the one we see the most of is the failure to disclose evidence, information that would exonerate or exculpate that defendant. There's a requirement, the Constitution requires that the prosecuting attorney tells the defense anything that they have in their possession or that has come to their attention that would tend to show either someone else committed the crime or the crime wasn't committed. And that's a constitutional right that every defendant has. And you would be shocked, maybe not, I don't know, but of how often that doesn't happen. And this it can be so many different pieces of evidence. It can be finding physical evidence that would suggest that someone else might have been the perpetrator. It can be witnesses that come and say, I wasn't telling the truth when I first reported the crime, or witnesses that say, I don't agree that this is the person, and they're supposed to let you know that there's a witness who would exonerate your client. And they're told, thank you very much, we'll call you if we need you. And it's never disclosed. Plus, very often we see that witnesses who testify at any trial, including serious homicide cases, have a strong incentive to testify for the government. They received a deal of some sort so that they don't have to face time in jail or face consequences for a crime. They get money very often, or they just simply, find themselves in a place where they want to try to trade something to the government in exchange for them helping out the government. And you've heard the term probably jailhouse snitches. There are so many people in prison who will reach out to the police department or prosecutor's office, federal, state, to say, I know you're looking for such and such a, case, into such and such a case. I have information to trade in exchange for reducing my sentence. And sometimes it may very well be that some of this is true and some of it is perjured testimony. But regardless, there's an obligation to tell the defense that this person has gotten a deal of some sort, a promise of leniency. And that information is withheld often, very often. Sometimes, the police have used threats to coerce testimony. That's never disclosed. Promises of all sorts, that's never disclosed. And so, that's just sort of a few things that can, qualify as misconduct on the part of the government. But that tends to probably explain most of the reasons for wrongful conviction. Another big reason that's come to light in the past 15 years is that a lot of the forensic evidence that we see on TV all the time and that we see in the real courtrooms too, it has come to light that there is not at all as reliable and as accurate as everyone assumed. One example, is fingerprints. When I was a public defender trying, a lot of cases, if they found my client's fingerprints in, the crime scene, I would really say to my client, that's it. There's almost no way to defend this. But now we know that fingerprint evidence is not the sort of, absolute certainty that we used to think it was. And the National Academy of Sciences, which is not a Democrat or a Republican or a defense lawyer or a prosecution organization, it's an arm of Congress created actually by Abe Lincoln years ago, reported in 2009 a whole list of pieces of forensic evidence that are nowhere near, if they do show that if there is some scientific validity, it's not as certain as has always been reported. So that's true for fingerprints. It's true for ballistics. They're very often, they will tell you that a particular bullet or a shell casing was fired from a particular weapon. That's extremely persuasive evidence to a jury. And then they're told that, there's sort of 1 in 10 million chance that it was a different weapon. And we now know that those, at least the statistics that they tell, the probabilities that they tell the jury are vastly overstated. So that's ballistics. We also have known for years that eyewitness identification, as impactful as it is in a trial, is just not reliable, that all of us are just, fall prey to things that will prevent us from really being able to recognize someone on another occasion, that we are distracted by so many things, that we have biases that pertain to race, and on and on. And I believe, and I used to write about this, I believe that there's no study that doesn't conclude that eyewitness identification is very fraught. And juries have been told that, but nevertheless, they're still allowed. And so very often that's sort of it's not that the person is lying or is committing perjury, but just believes that their identification is certain, and it's just wrong. And that comes to light very often. We have false confessions. I can't tell you how often people have said to me, who would confess to a crime if they didn't commit it? And there's a lot of answers to that. People who have been threatened by the police, people who are kept in custody under really miserable or worse conditions, who are withdrawing from drugs, who have diabetes, for instance, and aren't given their medication. And they're told, if you just tell us what we want to hear, we'll let you go, or we'll let your younger brother go, or what have you. And we've got false confessions. And how do we know ultimately that they were false? Or how do we know that the ballistics was wrong? And the way we started to know all that is when DNA came into being. And even DNA in its early stages wasn't as reliable as it was professed to be. But once it certainly is pretty strong now. And so it has exonerated people who confessed. DNA has exonerated people who were picked out of lineups, or exonerated people where, they had, gun evidence to show that the murder weapon was something that they had. And again, I mentioned race, but I really want to mention it again because the racial biases that we all have, implicit and explicit, have a huge impact on the result of trials. I won't go into much detail beyond saying one thing about it. There's a lot of ways in which that impacts, as I mentioned, identification, but racial discrimination in jury selection is a huge problem. And even though the US Supreme Court has ruled that it's unconstitutional for a lawyer to challenge a juror just because of race, it's very difficult to demonstrate that that's what's going on. And so even though it seems to be the case that that's exactly what's happening, it's difficult to convince the court of that. And so we often have jurors that are selected based upon trying to, in some way, have a certain racial composition to the jury. And then, of course, that does have an impact on the way evidence is perceived and about how a case is perceived even before someone gets on the witness stand. So I just want, the last thing I think I'll say, and then I'll turn it over to Megan. There are, as I said, there's a lot of innocent people that we know of who have been sentenced to prison and who've spent, if they're lucky, only a few years, but I can't tell you how often it's 20, 30, even 40 years before they're released. And for all of those people, there's probably way more that where the wrongfulness of their conviction just doesn't come to light. And of course, the main reason for that is there's just not that many resources available to bring these cases into court. Even with the National Innocence Network and innocence projects like ours all over the country, they're underfunded, they're understaffed, and you need a lot of lawyers and investigators in order to address all of the claims of wrongful conviction. And many of them we know now are very legitimate claims. And the tragedy of having people who have these persuasive, real and strong claims, the tragedy that they won't even be able to present that case in the courtroom is unsettling, to say the least. So I'm happy to take questions later, but let me now ask Megan to speak more about our project and what we've been doing so far.
Thanks, Judy. First, I truly want to thank you for having us speak tonight. Change does not happen unless there's people in this world who care about others as much as they care about themselves. And it's nice to see not only are there so many people who feel that way, but you've brought them together in a community and you have an interest in learning about injustices that others are facing, ways to correct them, ways to spread that message, to spend, your evenings when we're all busy, we're all working, we have so much going on, to learn how you can better your community is so admirable. And I'm so grateful to have people like that and to know that they exist in Delaware and that they're interested in what we're doing. Because change does come from communities, because oftentimes the people who need to change don't recognize it until they're held accountable. And in cases of wrongful convictions, the people who need to change are the prosecutors, the defense attorneys, the judges, law enforcement, and members of our legislature, who sometimes are the most resistant group to change. And part of that, when it really comes to the law and wrongful conviction, is it's groomed into us that we have the best justice system in the world, that America has the fairest justice system, that we're getting the proper results and we have trials. And our clients believe that too. I would say almost every exonerated person has said at some point, I wasn't that afraid to go to trial. I was innocent. So how could I be found guilty? I was going to get my day in court. I was just waiting for my day in court. And they're shocked that our system didn't work, because we're told, and everyone hears, we have the best system. And then the fear and despair going through the appeal process, where usually it takes multiple appeals and many years, if they get relief, to get that relief. And what they go through emotionally, losing faith in something that they believed in so strongly, is sad. And it reminds us that maybe our system might be the quote unquote best in the world, but it's still incredibly flawed. And thinking of that logic that something is perfect and is functioning well and not looking for where it needs to change is a problem that we face. And it's a problem that I faced starting out as a young attorney. I went straight into criminal defense, but I still had that belief that it's a great system and it's going to work. And I think, in all honesty, when I started, I don't know that I was someone that was trying to take on the world and create change. I just thought it was this really interesting job, and I wanted to be in the courtroom and I wanted to fight for our Constitution. And I didn't realize the whole other aspect, that I was representing a human who was going through the absolute worst time in their lives. I thought that I just had to practice the law and do what I thought was the fun side of being an attorney. And I thought that was all I needed to do to be effective and to be good at my job. And for a while, it seemed like that was true. I won my first 7 jury trials out of law school. I was getting incredibly good results because I would go to trial, and because I would do well, prosecutors are giving me great plea offers. And I wasn't embracing the human side of it. And I thought that's all I needed to do. I was getting you the best possible result. I didn't really know anything about you and your life and what you were going through, but I didn't think I needed to. And then I had this one client, and I worked, the majority of my practice was in Camden, New Jersey. Very, an area of tons of poverty, a lot of crime, a lot of corruption. And then I had a case that sort of opened my eyes to things that I didn't realize before. I had a client, he had a very long criminal history of drug use, drug sales. He was charged with distributing drugs, and he was facing, because of his criminal history, many years in prison. And because I had a good reputation and I fought really hard, I get him a probation offer. So no jail, no prison, couple years probation versus years and years in prison. I think no brainer. This is easy. Let's wrap this up. Let's go. And he says, no. I'm going, what do you mean no? What do you mean? And he goes, I didn't do this. And I said, well, I have a police report with a police officer who says that they watched you do this. And here are the drugs that they have in the lab that were tested and tested positive for cocaine. What are we going to do here? This is not a trial I can win. And he said, I didn't do it, and refused to take the offer. And I am very embarrassed to admit that I was incredibly frustrated with him. I was probably much too hard on him, and almost angry that I got him this great deal, and how dare he not take it and be so grateful for all this work that I did. And I say, fine, your funeral, I don't see how we're winning this trial. We'll go to trial, whatever. And I get a call a couple days before I'm supposed to pick a jury, and the prosecutor goes, well, I wanted to let you know, we're dismissing your client's charges. And I say, oh, well, that's a nice call to get on a Thursday. Why are you doing that? Well, we've learned there was an internal affairs investigation, and we learned that the police officer who said that he saw your client distributing drugs, he was involved with a ring of other police officers, and they were planting drugs on people that they had stolen from other drug dealers. They were also apparently stealing money that was supposed to go into evidence, and they would use those drugs to plant on people that they thought had information about crimes, and say, if you don't tell us who is committing these crimes, who's involved in higher up things, everything you know, we're going to charge you with these drugs that we found on you. And they had done that to my client. And it was all over the news. Lots and lots of cases were dismissed in Camden for that reason. And I felt like a terrible human being, because I had not for 1 second believed my client was telling me the truth when he said that he didn't do it. And that was a very eye-opening experience for me as an attorney. And I started to really look more closely at my cases. And instead of just believing what was in a police report, I started to go out to scenes myself. I went to drug sets in Camden, and I looked at where the police officer said he was, and I realized they just sometimes would make things up to put in a report. I was 50 feet away. That doesn't make sense based on where this was. That building isn't there. There's no way these things could have happened. And I started challenging what I was being told and doing the job that I was truly supposed to be doing, and listening to my clients and listening to their witnesses, and realizing that I can't just believe everything that I'm told without challenging it, and without realizing that there's mistakes, first of all, And there's also corruption. There's also this desire to win. I faced off against a lot of young prosecutors. I was a young defense attorney. We just wanted to win a lot of the times. It got very aggressive. And if you truly believe as a prosecutor that the person you're prosecuting has committed a murder, has taken a life, you're dealing with the victim's family every day, it's got to be tempting to cross a line sometimes. And we have to realize that defense attorneys, prosecutors, police, judges, we're all human, and we're going to make mistakes, whether they're intentional or, as Judy was saying, there's a lot of times unintentional mistakes happen in this line of work. And I started to see how much really needed to be done. And that's what ultimately led me to this job with the Innocence Project, which I'm very grateful for, to be able to focus on this work and do these things. But I've got to admit, when I first took the job, I'm not from Delaware. I didn't know much about Delaware, born and raised in New Jersey, lived in Philly for a little while with school. And I don't want to offend anybody, but in all honesty, I thought Delaware was sort of like a corporate town. I thought it was just a bunch of people with big office buildings, because that's what you hear is everyone's incorporated in Delaware. So I'm just picturing, it's where McDonald's and KFC and all the accounting firms live. And I didn't know a lot about it when I first took the job. And when I got here, I realized how much of a need there is for it. It's that sort of belief that we have the best system in the world. One of the words of warning I got when I took the job is that people would say, it's great what you guys are doing. It's wonderful that you care about people. And we think the work that's been done in other states, especially the southern states with death row, really great that people care about the wrongfully convicted, but it's probably not a problem in Delaware. We really, and I understand why they think that, because the Delaware bar, to become a lawyer in Delaware, hardest examination in the country, highest fail rate. There's incredibly few lawyers in Delaware because it's difficult to become a lawyer in Delaware. There's 10,000 people, I think, take the New York bar exam about every year. There's less than 10,000 people who have become lawyers in Delaware. I just took the bar last year and I'm number 6,777 of all time. So they really feel like we've picked the best of the best that have worked so hard to get here, and they're going to take it so seriously, and they're going to do the best job possible, that we are immune to what other states have gone through, to these horrible things we've heard somewhere else. We're still dealing with humans. None of us are immune. And so it's almost a harder battle to have people realize that we're facing the same problems here and we're behind in a lot of ways. Like Judy said, most other states had already had their own independent innocence organization. Delaware didn't. When we looked at the laws, Delaware just passed a bill that requires law enforcement to record interrogations to help make sure that we don't have false confessions that are one of the leading causes of wrongful convictions. We are working towards, with juveniles, because Delaware has a lot of cases where, as people that write to us, they were juveniles brought into adult court and convicted of crimes. It's one that we're actively working on a retrial right now, was that situation. And we're working on a bill that says you can't use falsehoods when talking to juveniles to kind of trick them. Trickery is what they call it, because as of now, law enforcement's allowed to lie to you when you gave a statement. When Judy's talking about the reasons for false confessions, it's because they can sit there and say, your co-defendant's in the room next door and he's blaming you. We got video. We've got files. This is your one chance to give us information. This is your chance to help yourself. And so we look at people that might be more susceptible. Anyone is susceptible to that, by the way. I've sat in those rooms with clients. I get stressed out just sitting in there. And I'm a licensed attorney who's been doing this for years. When you talk about a juvenile, even adults, to have them not protected for that. I mean, that's the Central Park case, right? They were all kids and they all said that we were there, we did this, we did that. Their stories didn't match up, but they were all convicted. We're working right now on a bill that says you can't use trickery on juveniles. And hopefully one day Delaware will start to expand that into adults. We do not have compensation for people that are exonerated. Decades of their lives are taken away from them and they're released. And that's a huge win. But released to what? When so many of their family members have passed away, when they have not seen technology. I was mentioning to a client the other day, well, it's on a hard drive. And he's just looking at me with this blank expression, like, what's a hard drive? And I realized he's never seen one, never seen, an iPhone, things along those lines. So they get out and it's a whole different world. And it's difficult to find support just to get yourself back on your feet and restart your life when you should have never lost a single day to begin with. And so that's what we're working towards, is getting that level of recognition so people understand that this is a problem here in Delaware, just as it is everywhere else. And I can say the response to our organization has been overwhelming. I get stacks of mail with people telling their information, and my investigator and I put together, unfortunately, we see a lot of common players. Sometimes it's defense attorneys who are ultimately disbarred. We've had a number of those, and yet their cases are left, those convictions are left, and their clients are writing to us. So putting all of that information together and trying to analyze that and sift through it, and it's a process. We get these stacks of information, and it's easy as a human to say, yeah, well, you went to trial and a jury found you guilty, or we read the court opinion and the court says, well, there was overwhelming evidence in this case, so you must have done it. And we have to remind ourselves that there are innocent people sitting in every jail and prison in every state in this country. And this could be that person's application because they all were found guilty. A judge all upheld their conviction. That's in every case where there was an exoneration. So it's a lot of time to look at them thoroughly and really consider and do the investigation, because unfortunately people write these applications, they don't have legal training. They might not know how to express the issues in their case. So we can't rely on just their application. We have to go and do our own digging and learning and figuring it out, because they might not know how to say to us the thing that we need to know that this is a case that we want to pursue on their behalf. So it's this fine line of resources of deciding we want to put adequate time into each letter, because this could be the letter. One of our board members who clerked for the Delaware Supreme Court and is a partner in a very large law firm. I remember when he decided he wanted to join our board saying, I truly believe, in all of my experience in Delaware, there are innocent people sitting in our jails right now. So every day when I get these applications, I think this could be an innocent person. And it's a harder standard than that, because we have to find evidence, something that can get us back into court. If their attorney did a terrible job, and I think had they had a better attorney, they probably would have won. That might not be enough to get them back into court. And then there's the flip side. Sometimes I see cases where there certainly was prosecutorial misconduct. You see cases where later it comes out that the officers involved in the case, like the case that I had, get arrested. Something goes wrong with them. Issues in these cases, but maybe it doesn't mean that they were entirely innocent. Maybe we can't prove it. And I have to let that case go, because that's not what our organization does. But what we do is fight for change in our criminal justice system, so that even if it's not a case that we can take for wrongful conviction, hopefully we're preventing it in the future, because to get to the point where we can get it back in court is difficult. It's a lot of work. It takes years and years. And I have to think that every day I can't move this case forward is another day that this person's sitting in prison. They usually spend an average about 10 years in prison for crimes they didn't commit, every day that it takes to do that work. So yes, we try to screen these cases. We send out applications. We work with the clinic that Widener has graciously helped put together for us to get students involved in this, to make change, hopefully for generations. But we also try to change on the other side, to have the laws change so less wrongful convictions happen to start with, because it's harder to fix them on the other end. but we're excited because finally COVID is lifting. We're going to get to have our first gala in May, which Dave McBride's law firm has very, very kindly allowed us to use their space. So we're in the process of planning that. I want to end on a happy note that we are glad that the community is recognizing us, welcoming us, and that now with COVID lifting, we have easier access to the jails, to fundraising initiatives, to networking, to meeting people. So we can have that community support because nothing changes without it. So again, I'm very grateful to you for being part of that community and for hearing what we're trying to accomplish.
Wow, Judith and Megan, thank you so much. I don't mean to. We'll get into questions in just a minute. In fact, I have one, but before I forget, I just want to say to you what a informative and powerful presentation the two of you have made. I think it's fantastic, and I'm sure that a lot more people are going to watch it on our YouTube site. I had a question I wanted to ask you, or get your reaction to certain things. And I think you know my one of my children, one of my sons, is a prosecutor in the AG's office, and one of the things that impressed me when he started, and tell me if this is wrong, but I have the impression that only a relatively small percentage of cases actually get tried. Most get result in plea bargains. And it's also my impression that the court system, the criminal justice system in our country, would collapse if most cases didn't get resolved by a plea bargain. And I know of the pressure that the judges put on the lawyers, defendants and prosecutors, to get a plea because they're concerned about the backlogs in their court and the burden on their court, and they don't want to hear that you're going to try the case. They want the case resolved. And while in a civil context, that's one thing. You're talking about plea bargaining someone's liberty or life. Well, I don't know how much it would happen in a homicide case, but I guess two questions. One is, how does this plea bargaining process affect the ability of the criminal justice system to deliver justice? And it just occurred to me when you were talking, and it opened my eyes. I'm not a criminal law lawyer. I don't deal in this area, that the police can lie to a defendant or a suspect to try to convince him that they've got evidence that might convict him. Can those lies be used to convince somebody to plea? I mean, can people enter into a plea deal being misinformed to what the evidence is against them?
So I'll start with your last question, then Judy might want to address some of the first ones, but so you can't lie to a defendant about the evidence as far as plea bargaining, but what you can do is not tell them things. So unfortunately, the way our system works, and it varies from states to federal, from different jurisdictions, but what they can do is they don't have to turn over a lot of evidence unless or until you go to trial. So if there's witness statements that someone's going to cooperate against you, that you might have more information, you might not get a lot of that unless you opt to go to trial and fight the case. So you're left to make this decision about whether you should plead or go to trial, sometimes without all of the information you need to know. So for example, I had a federal case. We got very limited information, and my client opted to file a motion to suppress. Only at the motion do I get a lot more information to learn that the police had fabricated things in certain reports, getting a chance to cross-examine them, proving to a judge they lied, to the point where one of the police officers, she made a finding, he lied in a search warrant. He was originally fired, and then they reinstated him after a 6-month suspension. We didn't know any of that until we chose to fight the case. But then that plea offer was off the table. It's not like we get to go back later if it doesn't work out in our favor once we've gathered all this information and say, oh, we want that plea offer now that we know everything. There are prosecutors who will say, if you file this motion, your plea offer goes up. we're going to start by offering you 5 years. But if you file a motion to say that something unconstitutional happened here to suppress evidence against you, if you lose, that 5 years is off the table and you have to plead to 10. So it's a lot of decision making about the risk of fighting for yourself and exercising your rights versus how much time will you have to do if you lose. And those are a lot of the conversations we have. And that's why the prosecutors,
that's incredible to me.
It matters a lot who the prosecutor is. So I'm sure that's prosecutorial discretion. There's a lot of great prosecutors out there who will look at a case and see the problems in it and say, you know what, you're right. You have a valid motion here. Let's talk about it. Let's see if we can work this out for something reasonable, or I'll leave the offer open. That's that prosecutorial discretion and control, why all sides really have to be seeking justice more than the win, or what the judges, like you said, want us to do a lot of times, just pushing that case forward, because a judge might not want to sit there and listen to a whole motion. So if you put pressure and say your offer goes up, if you don't take the deal now, the case will probably resolve more quickly. And Judy, I'm sure you have stuff to add from the first couple questions I left for you.
Yeah, sure. No, I'm glad you mentioned this, Dave, because it's an additional dimension to this. So at the beginning, my answers to the first sort of two parts are yes and yes. So yes, I think over 95%, I think the latest numbers are more like 98% of criminal cases don't go to trial. There are guilty pleas that are negotiated. And also the other part is, yes, the system would collapse if that weren't the case. Now, it wouldn't collapse if a lot more money was put into the system. It would collapse because there aren't enough judges in any jurisdiction, or enough prosecutors, or enough money for defense lawyers. And so the current system probably would collapse. The other reason I'm glad you mentioned it is that it also speaks about a lot of wrongful convictions or innocent people serving time did plead guilty. And then I think Megan explained how that could happen. And I'm convinced it happens a lot by my own experience and from reading cases. But those cases probably are rarely helped by organizations like ours, because those are the roughest cases to take. Because once there's been a guilty plea, there's almost like no legal hook anymore to get back into court. Only really if the lawyer was ineffective, and the law on that makes it so hard to prove. So innocence projects actually have to make a policy decision about whether they'll even look into a case where there was a guilty plea, because the chances of showing innocence and getting a judge to even hear a case are so much less that those people really have fewer chances of getting justice than people who've gone to trial.
So if I'm a criminal, if I'm a suspect, and let's take the situation where I don't know all the facts, and I'm given a choice. You can fight this, including by trying to find out more of the facts, or you can plead. And so I take a plea because I'm afraid if I don't, even though I'm innocent, I take a plea because I'm afraid if I don't, it'll even be worse. And then evidence comes out 10 years later that, say it's DNA evidence that would exonerate me. Is the fact that I accepted a plea, does that cut off the ability to vacate that conviction, or make it much more difficult?
Make it much more difficult, yes. And there are lots of places where, as a condition of giving you the plea offer, you have to waive your right to exculpatory evidence. You have to waive your right to, speaking about, suppression issues, that evidence was unconstitutionally seized. You have to waive so much of your appellate rights that the only thing really left is that someone forced you to plead guilty. You can always bring that up if you can prove it, or your lawyer was ineffective, and that's unfortunately so common, or that the sentence was illegal. But you never say never, and if something like that comes to light, maybe. But once there's a guilty plea, the system likes to think that the person, you have to admit guilt to get the plea through in most cases. And people like to believe that if a person admitted guilt, what are we worried about? We don't have an innocent person here. So it's a real issue. And when you think about how many people are pleading guilty, the number of innocent people who are doing time that way is probably shocking.
Sue, you've got your hand up.
I do. We talked at the beginning of this program, I think maybe before you joined us, Judy, that I teach a class called Racism in America, the history we didn't learn in school. And it starts with the early years, then slavery by another name, and then public policy. And then the fourth is mass incarceration and the war on drugs. And a couple of the things that come out there are the mandatory minimum sentences and the increased reliance on plea deals when there's a mandatory minimum sentence. And so that if you're convicted, the judge has relatively little in the way of discretion, and it's shifted the power to the prosecutors away from the judges in the context of what the charges are. And then there's a whole issue of how race plays into who's charged with what. The whole 3 strikes law, 3 felony convictions, not a violent one among them, is life in prison without the possibility of parole. And as I understand it, if you're convicted and sentenced to death, there are certain appeals processes and resources that accrue to you in trying to challenge that. But if your sentence is life in prison without possibility of parole, even as a juvenile, the likelihood is that you're going to die in prison. And the statistic that struck me in the midst of all of this is that I think it was in 1970, there were 200,000 people incarcerated. Today, there are 2.3 million. And of that number, 500,000 people are in prison or in jail awaiting trial. And so there is this huge incentive to reach some solution to the crime, to the plea, just to get out of jail. You haven't even gone to trial, let alone been found guilty. You're sitting in jail and somebody offers you a deal and you plead guilty to this. And so you can get out and you can go back to your family. The layers of, I don't even know what term to use. It is so disheartening to see some of the issues that are employed that act against justice in the justice system, without even layering race on top of it. Once you layer race on top of it, it's just kind of extraordinary. And the history of some of these laws that have resulted in an assault on the Fourth Amendment by the Supreme Court, civil asset forfeiture that puts resources in the hands of state, local, and federal police departments that militarize the police. The depths and the breadth of the issues at issue here are just kind of staggering, because I always thought, if you're innocent, odds are 99.99% you'll be found not guilty, and the reverse is true. It's been said facetiously, it's better to be rich and guilty in the United States than poor and innocent, but that is indeed what plays out over and over again. It's extraordinarily painful to watch, and I commend you for your efforts to overcome so many of these injustices that have been done, and I'm kind of wondering what else we can do to help.
Well, thank you. Everything you said is super on target in terms of what's going on. And you hit on so many different things. I'm guessing many of you already read the book, The New Jim Crow by Michelle Alexander. If you haven't, I just strongly commend it to you on mass incarceration. And my friend Christina Swarns, who's now the director, I guess, of the National Innocence Project. She was one of the few Black women to argue before the Supreme Court, talks about how the death penalty is really the new sort of lynching. So, race is a huge, huge problem in the system. What can you do? I think just, you've obviously, become really educated in these issues. And I think that talking about it to other people, because people don't realize, they don't, and it's understandable, if you don't immerse yourself in it, you don't really know. And the cases that we read about in the media are not necessarily the typical case at all. But so I think talking about it, I think, trying to support organizations like this. I mean, the problem that we're facing at the moment, we're very new, and Megan is amazing, and she gets up, I don't know what time, I get emails from her at 5 a.m, but she's one person, and we'd love to be able to bring more lawyers in. So but I think talking about it and doing what you can to support us is what you can do, and learning more, and one other thing, I guess I'll just say quickly, because this is something else people can do. We've all been hearing a little bit about progressive prosecutors. There is a real trend sweeping the country on the election of people who were not really coming, not coming from necessarily law enforcement perspective, but defense lawyers and civil rights lawyers who've been running for and being elected as a prosecutor, right? Philadelphia, we probably know about, and all across the country. There's a lot of backlash now because I know they're being recalled in California. Chesa Boudin is probably going to be thrown out of office, I think, in a couple of months in San Francisco. But there has been some improvement. It's sweeping the country, but still piecemeal, because prosecutors, you're right about the discretion of the prosecutors. In a way, it's their show. And some of the newer prosecutors that follow this sort of agenda of progressive prosecuting will have open file policies, for instance. So before you plead guilty, your lawyer can look through their file. And also have a priority to incarcerate fewer people, not more people. So voting, supporting candidates like that is something that's could be very important, especially if it spreads out more.
And Delaware's legislature has a significant number of representatives with ties to law enforcement that frequently gets in the way of discussion of meaningful reform. Can I put it that way without totally alienating everybody?
Well, that causes me to want to ask another question. I don't mean to cut off others, so please put your hand up if you want to shut me up. But we all know about the law enforcement officers' Bill of Rights and the efforts to reform that. One specific question I have is if a police officer has falsified evidence or failed to provide exculpatory evidence in prior cases, can the defense lawyers in a subsequent case involving that officer find that out? Or is that confidential and not accessible in any way?
It's confidential and not accessible. So the only way you're going to know is if it was part of the public record. So they said something during a suppression motion that was false. A judge made a finding that they testified untruthfully. Or if there was a civil litigation, sometimes it comes out on the civil end when there's police brutality, which is most of what we've seen in the news recently in Delaware, when we've seen police officers who have come under fire for multiple instances of police brutality. That's right now the only way to get access. We have the most secretive policies for police in the entire country. Every other state has reformed access to police personnel files one way or the other, whether you had to file a motion with the court to get them. Delaware, it's almost impossible to get information that should be accessible. I understand we want to balance the rights of individuals who are employed, but most other states have a way that a judge looks in a closed proceeding to make a determination if it's relevant to the case, if the defense attorney is entitled to it, and that's a fair way to go about it. There's a number of different ways it could be fixed with all different degrees of all the way towards being fully open, publishing on websites, to a little more closed camera, but there's ways to find balance. Right now, it's not balanced, it's not fair, and we don't find out until it's too late. And unfortunately, sometimes people lose their lives because information wasn't given when it should have been.
Mr. Morrison?
Thank you. I don't have a question. I just have a comment. Thank you very much for coming this evening and giving this presentation, especially in a place like Delaware, where we make lots of assumptions because we're all rational people, that in a state like this, the legal system operates in a reasonably proper way. And a part of what you're doing is shining sunlight, at least, on the fact that a state like Delaware has all of these problems in the operation of its legal system. I had the advantage or disadvantage of living in two states where practically everybody assumed that the judicial system was corrupt, and that was Mississippi and Missouri. But people don't assume that there are those problems in Delaware. And I think Leobor is one of the examples of the egregious miscarriages of justice, if you will, in the state of Delaware, and nobody expects that happens here. And a part of the work you're doing, I think, helps to put sunlight on that. And I'm delighted that you're here and doing this work, and we want to be helpful in any way we can.
We so appreciate that. And the knowledge of this group, just everything you've already learned, it's refreshing and it's exciting. And I'm glad that you're spreading those messages in the community and helping others to be as informed.
Judy or Megan, if you have to leave, please tell me, but I don't want to hold you up too much longer. But I had another question I want to ask you about. I can't remember the name of the case. The Delaware Supreme Court, I think, reversed the conviction, and the AG's office was attempting to make a decision whether to re-prosecute the case.
Yes.
He's our
Can you tell us
client.
a little about that and what's happened, or if anything's happened?
So there's a case currently, it's a client of ours, Mark Purnell, and the Delaware Supreme Court, for the very first time in its history, reversed a case based on the actual innocence exception. So Judy was talking earlier about some of the roadblocks of getting these cases back into court and how difficult it is. And there's a lot of procedural bars, it's too old, you didn't file the right motions. And the one way to get around all of the procedural bars is if the Delaware Supreme Court believes that there is evidence that you are actually innocent and they're sold on it. And for the first time in its history with Mark Purnell, they reversed, because he had procedural bars, they reversed his case on the actual innocence exception. They believed that he put forward enough that there was a viable possibility he was actually innocent. And the AG's office asked the court for time to look into the case again and make a decision of whether or not they were going to dismiss or re-prosecute. And they asked for a pretty significant amount of time that Mark Purnell sat in jail and waited. And they ultimately decided that they were going to prosecute the case. So the local counsel that Judy was talking about earlier, who dealt with one of the early exonerations in Delaware, he brought the case to Innocence, Delaware. We took it, we brought in a large firm as our co-counsel, and we're preparing to go to trial in the case. And right now the trial is scheduled to begin in August. There have been issues with obtaining discovery that we believe is exculpatory and would be beneficial to our client. So it's a process and it's been a fight, and we're concerned at some point whether offers are going to be made, what's going to happen, but we're proceeding and preparing for trial and keeping Mr. Purnell informed along the way, because you've got to realize how heartbreaking and emotional it is for him to sit in jail and wait for this second trial after the Delaware Supreme Court essentially said that they saw evidence of his innocence, and he was not released on any bail, and we're working towards motions in his case, but we are representing him and we're happy to do that. And that's what we're here to do.
And after the Supreme Court concluded, did the Supreme Court vacate his prior conviction?
They did, and they remanded it.
And he's still, and how long has he been in jail?
I want to say he's been in there.
I think, is it 10 years now?
Oh yeah, I was about to say over 10.
And
Because I think he was arrested when he was 16 or 17.
and they won't, and has the court refused bail or set too high a bail or what?
Yeah, the court did not grant bail. I think the judge, I would assume, is hoping that the case is going to resolve more quickly than it has. But as of now, he sits there.
Boy.
And he went through in the process of moving him. One thing that we were able to do when they first transferred him, he was put in solitary essentially, and he was separated because they said, you're now pre-trial. Even though he did very well while he was incarcerated, no issues, they put him back into pre-trial, separated him from anyone else. He was living in conditions where, he hears the same broken toilet was flushing every 10 minutes, lots of light all the time, really mentally damaging conditions. So we were able to relocate him from that, but obviously what he deserves is to be released.
On a more broadly speaking, even it's, there are all sorts of theories in that case about why they refused to drop the case when the evidence of at this point of guilt is so low. But there's a lot of reasons that a prosecuting an office or a particular prosecutor, there's a real psychological barrier to admitting to yourself, if not to the public, that you were wrong, or that you permitted something to happen that was unjust during the trial. People want to, and not to mention that there's a fear of lawsuits. But it is really shocking how often in the face of even DNA evidence, that a prosecutor's office will still really dig in their heels about not agreeing that this is not the right person. And what often happens, and this is talk about guilty pleas, so what often happens is that when the prosecutor just won't say, we were wrong, we had the wrong person, they'll say, look, we still think we had the right person, but we do understand the things you found now. So you know what? Let him plead guilty to the time he's already served. So your client could go home, but we're not going to say he's innocent. And, there are people who say, I've been here 20 years for something I didn't do, but I'll stay 20 more because I'm not going to admit to something I didn't do. But I don't know if I would do that. It's very hard. And so many people who really are innocent and really deserve to be considered exonerees have pled guilty in order to gain their freedom, because there is this huge reluctance to, just to admit what it seems obvious was what went on.
Reluctance on the part of the prosecutors.
I think we could go on for hours with this. It has been captivating. And I know a lot of us are familiar with statistics and theories, but to hear the individual stories of both those who are the targets of this and those of you working to right the wrongs has been really powerful. And I want to thank you both for your time tonight and for all the work that goes on. I think what is incumbent upon all of us, as you say, is to educate ourselves about the cases, about the stories that come to light, to vote, to advocate, to get involved, because the reality is there, but for the grace of God, this could happen to any of us. And I think that our role as members of a community, frankly, as Americans who profess to believe in fairness and equity and justice, it is incumbent upon each of us to educate ourselves, to speak up, to vote, to take action, to share the knowledge that we have. So thank you, Dave and Megan and Judy, for providing this for us tonight. And I just know that each of us who are here tonight are going to share our experience with others. And I'm predicting that our YouTube video will have a huge number of hits as a result of the time we've spent together. So thank you all.
Thank you.
Thank you,
Enjoyed it.
everybody.
Thank you.
Good night.
Good night.